time for rebuttal.
Well, I'm not going to let you backload it that much, Mr. Patel. We generally don't do that. So if you want to save, 4, 5, 6 minutes of your time for rebuttal, that would be fine.
I would certainly have that.
I'm sorry.
I would definitely have that.
Okay. Have at it.
And now, this appeal is from a final summary judgment of a foreclosure case from Hillsborough Circuit Court. The plaintiff here in appellee, then Wells Fargo Bank, initiated the action with an unverified complaint to foreclose with a count to re-establish lost note and without any copy of the mortgage note attached. Subsequently, the plaintiff filed various copies and differing versions of the purported note without presenting the original note during the entire proceedings. During the course of the proceedings below, the plaintiff, now appellee, was substituted by appellee by filing an assignment of mortgage only. Appellant has consistently opposed and has shown that appellee, the plaintiff below, lacked standing at the inception of the case, throughout the case proceedings, and at the time of obtaining a summary judgment. Second, the plaintiff appellee lacked capacity to sue as an unregistered trust in Florida in violation of various Florida statutes. Third, the lower court entered the summary judgment despite existing genuine issues of material facts and pending counterclaims, including fraud.
Mr. Patel, I would like to ask you a couple of questions, if I might, so that I clearly understand the record below. This lawsuit began on March 18th of 2008. At that time, were you a legal title owner of the property?
At the time, I was in possession of the property, not
No, sir, that was not my question. My question was, did you have legal title to the property?
Not at that time.
Okay. You acquired legal title to the property during the pendency of this action and a deed from your former spouse as a settlement of something?
As a quit claim deed, yes, during the proceedings.
Did you file a motion to intervene?
I did not file a motion to intervene,
Okay.
and
You were named in the beginning part of the suit as the unnamed tenant, is that right?
yes.
Okay. My next question was, and I begin by thanking you for your response to the order to show cause why the case should not be dismissed for lack of jurisdiction. And in your response, you cited a Supreme Court case of Castro. Do you recall that?
Yes, I do.
Okay. Castro came out in 1981. The rule that it interpreted was modified in 1984. So as this court noted, that rationale no longer is appropriate, and we pointed that out in a decision called Fisher in 2001. So that case does no longer, pardon the expression, competent authority to sustain your position. This court said the outcome of Castro has been changed by amendments to the rules of civil procedure, which replaced the phrase entry of judgment with either filing of judgment or rendition of judgment. So with that, I'm still concerned whether or not, as a matter of law, your appeal was timely filed. And I know you are pro se, but I wanted to give you a response because this is the only time we get a chance to talk to you.
Yes, I argued both the appellate rules. I studied that, and appellate rules also clearly the wording shows that when the time of judgment is rendered, and the definition of rendered includes the day when the clerk enters dockets. So here the date the judgment was docketed was January 19th, 2001.
Thank you, sir. You still have your time. Go on. I just wanted to ask you the questions before you sat down, before we electronically lost you. That's all.
Court case, but then there were subsequent revision in the rules of procedure, Florida rules of procedures and appellate procedures. But the clear-cut definition has been so far evolved is from the date the judgment entered into the records, which was wrongly stamped though on the face of it. But the record reflects, the clerk's record on appeal reflects that it was entered, docketed, and recorded on January 19, 2001. So I would say that the appeal was timely. At least the motion for rehearing, subsequent motion for rehearing was timely.
Mr. Patel, we don't say whether you are right or wrong right now. We have to go back. There's three of us. We have to discuss the position you advanced and your opposing counsel. So you need to go ahead with all your argument and you'll hear from us in writing.
Yeah, I have presented my argument as far as the appeal is concerned. I was addressing your honor,
And I appreciate your response. I very much appreciate it because, like I said, it's the only chance we get to talk with you.
I appreciate sir too. And right now I will reserve my time for the rebuttal.
Okay, I'm going to give you 6 minutes for rebuttal, Mr. Patel.
I appreciate it.
Okay, Mr. Diaz.
Good morning, Your Honors, and may it please the court, Adam Diaz on behalf of the appellee, U.S. Bank. This is a very old foreclosure case. It's probably the oldest foreclosure case that I have actually handled in my career, and a lot of things happened in the lower tribunal, which eventually led to a final judgment for foreclosure. However, the outline of the arguments I'm going to present and the evidence presented to the court support affirming the final judgment of foreclosure. So the first argument, and actually I just want to clarify for the record, Judge Casanova, your question regarding how Mr. Patel acquired the property. The deed in this case that I believe was in 2011 to Mr. Patel in the record, that deed was actually from his daughter, Shri Patel, not his
Wife,
former
that's wife,
spouse.
from his daughter.
Right.
It was Exhibit I in one of the motions, I believe.
Yes, Your Honor. And so he acquired title to the property, co-title with his spouse, ex-spouse, in the middle of this case. And Shri Patel was dropped from this lawsuit because she no longer had an interest in the property as an owner. So
Does he have any ability to enter as an intervener, acquiring title after the lawsuit is filed?
he didn't have to intervene because he still had possession. So he had possession from the beginning of this case till the end of this case, until the eviction of the property that took place later down the road. So
He had possession as what, without a recorded lease?
Correct. He was just an unknown tenant. There is transcripts throughout the so there was a huge portion of this case, and I believe your honors can see in the record, a huge portion of this case was litigating who was properly representing who in this case, because Ms. Patel had no idea she was being represented by a prior attorney. This is the first time I've ever had a case where one attorney was suspended and then ended up losing his license. Mr. Patel's initial attorney in this case was suspended for 30 days. So there was a lot of different issues in this case that add color to the case, but don't really have any bearing on whether or not the court properly affirmed judgment. So the first argument in this case,
It was interesting going through the record.
And I had to relive it preparing for this, and I had a little bit of PTSD reading through this because this was a very, very long history of a case for me personally. But the first argument is there's multiple. The complaint was not verified. Well, in 2008, there was no verification requirements. The complaint was amended twice in this case based on motions to dismiss, which if you read the record, I believe should never have even been filed. But both of those amendments were verified and contained a copy of the note endorsed in blank. So the unverification of the complaint and the failure to attach the note to the initial complaint back in March 18th, 2008 does not negate standing in this case. So we have to go to what happened in this case. In 2009, the original note was filed with the court. In 2010, a final judgment, I believe it was a trial, was entered and the court accepted that note as the original note and rendered a judgment. So that's where the original note came into play in this case. It was ultimately vacated due to a course of pleadings. Case was litigated. We went to a summary judgment hearing. So what was attached to the summary judgment motion to prove standing at inception? Well, there's two ways that standing at inception were proven in this case. The first way is Wells Fargo was the originating lender, brought this case in their own name. So they were the originating lender and the note was made payable to them. Second, we established that Wells Fargo had possession of the note with the blank endorsement prior to filing. This is in the record on 1668 to 1672. I believe it was Exhibit C of my affidavit of summary judgment. And it's a Bailey letter from Wells Fargo to the law firm 4/16/2008, which is 2 days prior to the filing of the complaint, that shows they had possession of the note endorsed in blank. So we showed that Wells Fargo had possession of the note. Then in the middle of this case, and I believe it was in 2014, if I recall, the loan transferred to the current appellee. We have established standing in that case now, because now, based on the cases of Spicer versus Ocwen Loan Servicing, or Wilmington Savings Fund versus Stevens, that's 290 Southern 3rd 115, 4th DCA 2020 case, they acquired standing because the note was in the possession. Even though it was in the court file, it was still in the possession. And the Stevens case actually addresses that right on its face. That case was a little interesting because in the Stevens case, the note was in the court file, case substituted, case went to an actual evidentiary trial, and the opposing counsel objected to the note being removed from the court file for the substituted plaintiff to prove possession, because they never physically had possession because the note was filed in the court. The judge agreed with opposing counsel in that case and rendered judgment for the defendant, saying he never had possession. I personally handled that appeal, and the 4th DCA said no. Just because a clerk of court has possession doesn't mean that negates standing for a substituted plaintiff, because Spicer, which is another 4th DCA case, goes through the rules for standing of a substituted party, and a substituted party acquires standing so long as the prior plaintiff also had standing. So we established standing through possession for US Bank based on the note being in the court file. We also attached a purchase agreement within our motion for summary judgment that showed they also paid consideration and owned the loan. So we provided standing 2 ways in this case for both parties, ownership and holding, which I don't think you see in a lot of foreclosure cases, but in this case, it was a 2008 case, so it required the evidentiary burden. So then the next question that comes is, who are you going to believe in this case? Mr. Patel filed an affidavit, which I believe doesn't conform to the rules, to show that he had personal knowledge that the note was not the original. But we know that initially Judge Ralph Steinberg in 2010 found that note to be original. Ms. Patel filed a consent judgment in this case, where she stipulated that the note was filed with the court and that it was the original. And then we had Judge Huey, who did the motion for summary judgment, who deemed the note to be original. Then we had a motion for rehearing on the same issue, on whether or not the note was the original. Judge Huey again affirmed the note was the original. And there's been no evidence presented to the court at all that this note was not the original note. There was multiple copies, but remember, this was a 2008 case. So back then in 2008, things were stamped, holes were put into it. The copy on the docket has 2 holes because they're paper copies that are held in the court. And that explains it. And minor alterations to the note alone do also not negate standing. That's the case cited in our brief, Cronin versus Deutsche Bank, where they said that the note had different redactions on the multiple versions. And the court said that still doesn't mean you lack standing because of those alterations. And here we had now 2 judges and 2 counsels and 1 party that viewed the note and said, this is the original note. That's sufficient to prove standing in this case. And then I think it's important because the judge took this into consideration. Mr. Patel's interest in the property was just the possessory interest. He has no obligation on the note, no liability for any loss of the property. He, in the record, I believe there's a transcript that does state the property was rented. And the only party that had a true interest in the note was Nutan Patel, who surrendered the property in bankruptcy. This case gave light to the case Henry Metzler from the bankruptcy court. It was one of the first cases in the Middle District of Florida at that time that discussed what surrender of property entails in a bankruptcy. And in that case, it said, based on Nutan Patel herself, based on the ability that she decided she surrendered the property, she can no longer dispute the validity. And she stipulated to everything in this case because she knew she lost the right to contend and fight this case. And if you read the record, especially the sanctioned transcripts, she wanted this case to be over. She really wanted this case to end. She was on the hook for the note. Her daughter was at some point going to have a judgment against her as a young woman, and she did not want that for her child. And she stipulated to end this case. And that was in 2015. And it took a very, very long time to get there, but we ended up getting there. And there's nothing in the record to support any of Mr. Patel's arguments that the plaintiff actually lacks standing. Now, I think the next argument that I probably should have started with first, but is whether or not this appeal was timely. My reading of this court's order is that the appeal may not be timely because the notice of appeal in and of itself says the motion for rehearing was not served. And that's how I read the notice of appeal. And I believe that's what triggered the court's inquiry on the order to show cause and whether the motion for rehearing told the time for appeal. The response filed by Mr. Patel doesn't address the issue of service. The rule in this case is not whether or not the rehearing was filed. The rule governs whether the rehearing was actually served on the parties, and that would toll the appeal. There's nothing in the record to show that it was served on the appeals absent the certificate of service of the motion itself. However, I think there's an admission here by the prior counsel that it wasn't served on the notice of appeal, which is something unique that I will say I have not seen that before on a notice of appeal, that type of language. Because of that admission in the notice of appeal, I do believe this appeal is untimely, and therefore it should have been dismissed. But there's nothing else in the record that I can point to show you that it was in fact not served minus that admission. So with those reasons, Your Honor, I believe that on the merits of the case, we prove standing for Wells Fargo at inception 2 ways, US Bank at the summary judgment hearing 2 ways. It's undisputed in the record that this was the original note surrendered to the court, and at a minimum, this appeal should be dismissed based on the admission of prior counsel, Mr. Husby, that the rehearing was not served and the time to appeal was not told. Unless there's any questions, I reserve my time.
Thank you, Mr. Diaz. Okay, Mr. Patel, you're up to rebut.
Yes, the appellee raised these questions as the owner or of the property, but the appellee was not themselves substituted in the action till 2014. So, and in their subsequent motions for summary judgment, and also by filing a notice of dropping the party, which was Sri Patel, from whom I got the property rights, they admit and they dropped Sri Patel, saying she's not the owner anymore and has been quit claim deeded to myself, the appellant. So, of course, the lower court was blatantly misled that I'm not the owner of the property, of the record. That's one thing. And the appellee is trying to say the validity of the note. Now, with the first complaint, there was no note. Then they had a filing purportedly of filing of an original action, original note. Then subsequently they filed amended complaint, the first amended complaint. And then in the verification, this was the first amended complaint had a verification and it had a lost note count. So subsequently, even after filing of a purported original note, they realized, the plaintiff then, that the note is not original, or they don't have the copy of the note, or they don't have the note, or neither the holder or they are in possession of. Now they have 4 affidavits in the record, which always says amount due and owing. And every time in those 4 affidavits, they mention that they are servicer of the loan. They never mention that they are holder and they have right of as a holder and the possession of the note to foreclose. Second amended complaint, they filed a different version of the note with no endorsement. Somehow, from the first amended complaint, there was an endorsement, undated endorsement to unknown. In the second amended complaint, the stamp of endorsement disappears. And the party got substituted by just an assignment of a mortgage. So they could not establish the standing, and they have not addressed the issue of capacity to sue. And there were material issues, extensive affidavit filed before the summary judgment was then entered. Material disputes still remain, and summary judgment should not have been entered. I'll raise my arguments.
Okay, thank you very much. Thank you both.